Thank you. So that's 5 questions in one, if I count it properly, in rather different fields. Access to medicine, very important topic, and as you know very well, the EU has been clearly one of the most active proponents of the change to TRIPS agreement that allow compulsory licenses for exporting generic medicine to countries in need who do not have manufacturing facility. I don't think this can be denied. So there is no reason why we should suddenly be against it, clearly. You've mentioned there have been dozens of cases, etc., etc. No, that's not true. There's been 8 cases in one country in 2008. And that's it. There's not been any more cases in 2009, I'm sorry. No, there are constantly, of course, checks by customs, yes. But what I mean by a case of medicines being held, being detained temporarily for patent litigation purposes. And this was only in one country, because in that country, for some reasons, there had been creating a jurisprudence which we don't share, and we are taking care of that with our colleagues of customs to make sure it doesn't happen. The reason also that it didn't happen in 2009, didn't happen since 2008, is because we took care of it also with the right holders who have committed not to use, even if they could, legislation for that. But we are fixing the law, and of course the purpose is not to hamper access to legitimate generics, if you want, in transit. This being said, it should also be reminded that counterfeit of medicine is a problem, and that customs do have to control medicine, and you can't just create a kind of a valise diplomatic category for medicine where you could just put anything in the box and say, generic medicine in transit, please do not open. So this is not a situation where we want to go, because we're also a duty vis-à-vis our citizens, but also vis-à-vis, in case of transit, of other citizens where the customs might not be as efficient as our European customs, and I think it's fair to say European customs probably also saved many lives. Particularly in developing countries where the issue of counterfeit medicine is much more acute than in Europe or developed countries where the health system is pretty tight. Your second question was regarding the new or directive, what you call IPRED, IPR Enforcement Directive 2. This is totally, I mean, it's a different agenda. I mean, clearly the member states would not allow that the debate on this directive, if there is one, because this is for Commissioner Tajani to discuss. I'm sorry, I'm not updated yet. To discuss whether they will make a proposal, but clearly there will be a proposal and presumably a debate. I say presumably because there's been one in the past in the Council and the European Parliament, and to imagine that the Commission could just sneak this discreetly with the Parliament, which we have to ratify anyway, all international agreements, including ACTA, is simply not realistic. I mean, there's just no rationale to that. Even if the Commission were the most cynical, it just wouldn't fly. So perhaps there is intention to harmonise in Europe the issue of criminal sanction, because it is a problem. You do have to realise that we don't negotiate anything with third countries on this aspect, because we have no acquis. This is a ridiculous situation. We are the ones suffering from our intellectual property right being stolen by counterfeit, which are most of the cases are non-European. So it is very much in our interest to have some legislation there. But it is not for here, for now, to do the debate. This is a debate which will have to take place with the Council, with the European Parliament, etc., and all voices can be heard. You've mentioned the issue of having the negotiations outside of the WTO. I fully agree with you. It would have been ideal to have this kind of negotiation in the WTO, because the WTO has advantages which you cannot find anywhere. It has a binding dispute settlement. It's the only binding dispute settlement in international intellectual property, so it's very important. The problem is, and this is the reality, as a speaker for the EU in the WTO on this matter, I know it for a fact, that we can't even speak of existing enforcement practices. It's been denied from the agenda several times by some countries who do not even want that we simply say, okay, this is how we apply the WTO existing rules, TRIPS agreement, this is the problems we're facing, this is where we think we've made progress, etc. Simply in a non-binding not pedagogical, but if you want, purely explanatory manner. It can't even be on the agenda. It's amazing. They veto the agenda. So to think that you could go beyond, and I'm sorry, you can't have your cake and eat it. You can't, at the same time, hope that we have a discussion in the WTO, which is consensus-based organization, and at the same time dealing with countries who do not want the attempt to be agile, which is perfectly their right. But then those who want to go beyond because they're facing problems should be allowed to do so. You've mentioned a question on ISP liability and the safe harbor. Yes, as you know, our acquis provides for, if you want, conditional exemption of liability, and this will not change. I can only repeat, it will not change. You can say that you disagree, but then you should perhaps see the text, which we hope we can show you. But clearly, because, as I've said, we're going to try to reach a consensus on this, and it will not change anything. And to your last question on criminal sanction, whether they will hamper whether innovation, chill the innovation, yes. You have the copyright on that one. Well, it's only logical. If you follow the logic that we're not going to change the acquis, we're not going to change the existing rules, and as far as I know, innovation is not exactly chilled in Europe, then you have the answer. It will have no effect. Other questions? Sir, please.
Yes, this is Philippe Cohen for the UNIFAB, for the, on behalf of this association, which does exist since 140 years, representing all sides of industries. And my name is Philippe Cohen. I just wanted to share with you my surprise vis-à-vis the whole size of the emotion that has been around this debate. Emotion, why? Because there is no dual approach or binary approach between the right holders and the citizens. For us, it's really the same fight. And what is defended by the right holders is also the same priorities as the one defended by the citizens, namely the security, the economy, the employment, safety, and innovation as well. And you don't have to be a big company to be innovative and to be willing to be protected by IP rights. Concerning the initiative that has been summarized by Mr. Devine, I wanted to, on behalf of the UNIFAB, to salute the effort, and especially the fact that it's a worldwide approach, which is exactly what is missing in this debate since years. We have all been trying to fight to get a sense of transfrontier infringement issues, and for the first time, we have a real sense of effort at a quite large worldwide level, and that's not to be missed as an opportunity. In terms of due process, I wanted to thank you for all the reinsurances that you have been able to provide on, especially on the acquis, on the non-criminalization, on the fact that it's not about trying to pursue the individuals, but really to try to harmonize much more than what has been done in the past, the rules and the regulations where we can acknowledge a lot of gaps, and the gaps are really the killers. And the last point is about discretion and confidentiality. Just wanted to remind you of this story that was part of the film of Mr. Orson Welles in 55, Mr. Arkadin, where there was this very powerful king, and I'm not saying that the EU Commission is a king here, but the king says to the poet, what can I offer to you? And the poet replies, everything but your secret, meaning that secret on a temporary basis have some virtues, and I bought those virtues, so that's what we wanted to add in this debate.